Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them, so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, the show dedicated to finding the answers to our elder care and estate planning questions. I'm your host, Mary Ravazio, and joining me is Doreen Seamon of Seamon Law Offices, whose practice focuses exclusively in elder law and estate planning. After witnessing the estate planning needs of friends and family, Doreen graduated from the WVU School of Law, focusing on estate planning and elder law. Doreen is licensed to practice law in Pennsylvania and West Virginia, but is currently focusing on the estate planning and estate administration needs of West Virginia residents. As a member of NALA, Elder Council, and Wealth Council, Doreen stays on top of all the latest laws and news that affect her clients. Doreen, welcome.
Thanks, Mary. It's great to be here today.
Now, Doreen, we talk about the various aspects of estate planning every week, but I often hear people discuss it as something they need to take care of when they get older. So really, exactly when should a person start creating an estate plan?
Technically, when a person reaches 18 years old, they should at least have powers of attorney completed, because at that age, their parent or guardian's no longer able to make legal or even medical decisions for them.
Yeah, but it's very unlikely that an 18-year-old or even a person in their 20s is going to need those types of documents.
Well, the youngest person I've worked with who had a medical emergency requiring those documents was 21 years old. It was a very serious accident, and the client was in a rehabilitation facility. It was an extremely serious situation. I can tell you right now that her parents were so distraught that they would have been very thankful if they had had those documents in place before her accident.
Well, that isn't something I'd want to think about if my loved one was that seriously ill or injured.
Exactly. Regardless of your age, if you had a car accident or a stroke or some serious injury or illness, think of the stress on your family as they drop everything to be by your side. They might have their own family members dependent on them or a job, but on top of all of that worry and stress, they're trying to figure out how to get the legal authority to pay your bills, deal with your insurance company, and protect your medical decisions and finances.
I certainly wouldn't want that stress on top of everything else. So if a loved one has a car accident or something else that makes them incapacitated for a period of time, we'd need you to create a power of attorney for them at that time?
Mary, if that loved one has the capacity to understand the impact of what they're signing or have another sign on their behalf, we can create the documents at the time of the emergency.
How does that work? Do you have to go to them?
Yes, an attorney from our office usually must travel to the facility to explain the documents and to verify the person wants to execute those documents and that they understand the impact of what they're signing and that they're not being pressured to sign the documents.
And is it more expensive in an urgent situation than if they plan ahead?
Yes, it's more expensive because we have to work quickly, and it usually requires an attorney from our office to travel to the location of that person. So it's not only more stressful because of the urgency, but then there's also the time and expense of traveling to your loved one. It's not the ideal situation.
If you go to the hospital or rehab facility or wherever that person is, and you find that they just don't really have sufficient capacity to understand what they're signing, well, then what?
Well, sadly, then we'd need to work with the family and go through a court process called a conservatorship.
What is a conservatorship?
Our office would be engaged to petition the court requesting it to appoint somebody to manage all financial aspects on behalf of the incapacitated person. If that person didn't have a medical power of attorney appointing a healthcare representative, we would also request a guardianship to have a person appointed over medical decisions as well.
When you say a court process, that sounds like this isn't just going to happen overnight. It may take some time?
Yes, you're correct. It requires us to draft an actual court document called a petition. So it's not something we just whip up quickly. First, we must obtain financial information and physician opinions regarding the person at issue. Then we must give notice via certified mail with return receipt requests to anybody who's deemed an interested person.
An interested person? Who's considered an interested person?
Well, the person who's having the capacity issue, as well as their family members.
What do you mean by give notice?
The family members who are considered interested persons receive at least 14 days notice via certified mail with a return receipt requested. But the sheriff's office must serve notice to the person with the capacity issue at least 14 days prior to the conservatorship hearing.
The sheriff? But isn't it just usually a parent or a child or somebody close to the person who is offering to step in as a conservator? I mean, that seems like a lot of work to do when most of us would just know that it makes sense for that person to do these things for their loved one.
Yes, it does seem like common sense to make it easy for us to know who that person would have chosen, and it's pretty easy and affordable for that person to be responsible before the emergency by executing a durable power of attorney.
But if we don't execute a durable power of attorney while we're healthy or at least have capacity, we're putting an unnecessary burden on our loved ones to go through this conservatorship process if we lose our capacity for a period of time in the future.
Yes, that's what I'm saying. We routinely maintain our home and our automobiles to keep our family safe. And we even further protect them when we buy insurance for our home, health care insurance, automobile insurance. This is similar. It doesn't mean you're old or having health issues. It's just the grown-up thing to do. Like my young adult children call it. It's adulting.
Adulting, I like that. That's great. I can't see why every adult wouldn't want to have this in place in advance as opposed to a conservatorship. And how long does a conservatorship take?
Well, as I mentioned, we would need to draft and submit the petition. And then once the court sets the date of the hearing, we must have the person served by the sheriff's department at least 14 days prior to that hearing. We also have to obtain medical records and the opinion as to the person's capacity prior to the hearing. Then the court appoints an attorney on behalf of the person who we're requesting a conservatorship for. That attorney is referred to as a guardian ad litem.
So after all that, once the hearing is over, we have a conservator?
Yes, but even then it takes more time because we need a signed court order to make it official. Obviously, it can take a little time for the court order to be drafted and approved by the court. All in all, an extremely smooth conservatorship proceeding would take at least a month from the filing of the petition.
And that's probably more expensive than just having a power of attorney executed while we are healthy too?
Yes, and don't forget that during that waiting period, nobody can take care of these financial affairs and decisions, and companies such as the bank or insurance company can't give access to the family until they have the legal documentation as to who the conservator is.
Now, we know as adults we should all execute a durable power of attorney, but for those who still don't, it sounds like your office will help the loved ones obtain a conservatorship?
Usually, but just so our viewers know, our office doesn't accept contentious conservatorships. So if family members are disputing who should be conservator, they should just hire a firm that litigates.
And of course, fighting would take more time and more money. So thinking about time and money, I recently saw some shocking numbers regarding the high cost of nursing home care in West Virginia.
Yes, we are the fourth most expensive state in the country for nursing homes. According to MedicaidAnnuity.com, the average cost of a nursing home in West Virginia is now at least $9,703.
Wow. So we might as well call $9,703 $10,000. And I wouldn't think that most West Virginians can afford $10,000 a month for very long.
I don't either. In June 2015, the Government Accountability Office determined that the average Americans between 55 and 64 years old only had about $104,000 of retirement savings.
That wouldn't even pay for 1 year. So what advice do you have for us?
We need to understand the facts and our options. First, some people mistakenly think their Medicare will pay for this expensive care, but it only pays for up to 100 days.
So that's only about 3 months. And is the 100 days a sure thing?
No, it isn't always 100 days. There are Medicare guidelines to determine how many of the potential 100 days a person gets.
Okay, so after Medicare coverage ends, then how do we pay?
Then we're personally responsible to pay for the care. We may have chosen to purchase a type of long-term care insurance to help with that expense, or in my experience, most of my clients haven't done so.
So long-term care insurance products may help, but you probably have to purchase that in advance.
Yes, you can purchase these products proactively while you're still young enough and healthy enough to qualify. Once you are very ill or advanced in age, you're probably not going to qualify for this type of insurance.
What if I just don't have the money to pay that high cost of care? What happens to me?
Well, if you have resources, you must spend those resources until you no longer need that level of care or you're broke. Once you're broke and still need that high level of care, you would apply for Medicaid.
Okay, so for the average American who has $104,000 in retirement savings, living in West Virginia, and needing skilled care in a nursing home, they may qualify for Medicare coverage for up to 100 days. But then they would pay about $10,000 or more per month for care. Then within 1 year, they will be broke and need to apply for Medicaid?
Yes, that's a typical scenario.
Well, let's talk about what it means to be broke. I mean, what assets count when a person applies for Medicaid?
A single person who's not married may retain a home, a vehicle, insurance with less than $1,500 cash value, a pre-need funeral and burial plot, and up to $2,000 of other assets.
Well, at least they get to keep their home.
Yes, but realize when a person applies to Medicaid, they must agree to estate recovery.
What is estate recovery?
It's the process that occurs after a person passes away, where the state can put a lien on the home to recover some of the costs for paying for their care to reimburse Medicaid.
Okay, now I've heard about a new deed in West Virginia that prevents that from happening. I believe it's called a transfer on death deed. It transfers the home automatically when you die to avoid probate, and so it avoids estate recovery too?
Well, yes, there was a lot of excitement when this new type of deed became effective in West Virginia in 2015, because a lot of people hoped it would be a way to protect the home. But what a lot of people don't realize is that in 2016, West Virginia's DHHR updated its estate recovery rules to permit it to place a lien on the home with a transfer on death deed before the Medicaid recipient died.
So a transfer on death deed isn't really a fail-safe solution then?
No, it's not. There are various deed options that people use to avoid probate and a potential Medicaid lien. They all have advantages and disadvantages, and we're happy to discuss those during our estate planning consultations in conjunction with other options that we offer.
If the deed options like the transfer on death deed don't work, what can we do to protect our home or even other assets that we've worked so hard for?
Plan ahead. For some of us, that may mean long-term care insurance. For others, that may mean a near revocable trust. And for those of us who really want to be prepared, maybe both insurance and a trust.
So the irrevocable trust is an important piece of the estate planning puzzle. When Elder Care Answers returns, we'll talk more about irrevocable trusts and gifting. Stay with us. Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Now, before the break, you mentioned the irrevocable trust. That's what you call your box, right?
Yes, in our office, we refer to the irrevocable trust as our box. But of course, we thoroughly explain that it's really a trust. It's just that irrevocable trust is quite a mouthful.
Yeah, plus it's easier to visualize how our box works. It's similar to a safe where we put our valuables, then we lock it up for safekeeping.
Exactly. There are many types of irrevocable trust to achieve a variety of goals. But when we discuss our irrevocable trust that I refer to as our box, it's usually to achieve asset protection from the high cost of long-term care.
So how does a box help?
Well, if your goal is to protect specific assets from the high cost of care, you essentially have to give them away to a person or a box.
That makes me nervous because if I give my stuff away, how do I know if I needed it or just wanted it back that I could get to it?
Mary, if you gift something, you don't have a legal right to get it back. For example, if I gave you this pen, legally it's yours. I can't demand for you to return it to me. Now, of course, I know you would because you're a nice person. But what if you had passed away and it had been transferred to your beneficiaries and they won't give it back? Or you had your own creditor or health problems and you legally couldn't give it back. I may never get my pen back again. So I better be prepared that if I give it to you, I might not get it back.
So a gift is just that, a gift. We don't reserve a right in that gift. Now, I've heard of many people that gift homes and other assets to their children to avoid probate and to try to protect those assets from Medicaid.
There is a lot of misinformation out there, and I see that as well in my practice. So here's the thing. If you add your child or children's names to your deed, you are adding them as an owner. If they're married, it doesn't mean your son or daughter-in-law owns part of it, but it does mean that if you and your child decide to sell it, there's a good chance their spouse will have to sign the papers too, because they do have a sort of marital interest in it, and your buyer will want the peace of mind to know that there's not any chance that he or she will try to say that interest was violated.
That sounds like a lot of people who would have to work together. What about if something bad happened to one of the children on the deed or the bank account? For example, a health issue, divorce, or money problems. If their name is on the asset, could that affect me?
Yes, I always say that bad things can happen to good people every day. Just open your newspaper.
So the box allows us to gift without worrying about those issues.
Yes, boxes do not get divorced, addicted to drugs, or pass away unexpectedly. They just sit there and hold your valuable assets.
I like that. That makes sense. But what else do we need to know about the box?
Well, every gift, including a gift to a box, has a 5-year look back, meaning that we can't just give everything away today and immediately qualify for Medicaid. Gifts within the 5 years preceding a Medicaid application could cause a period of ineligibility.
So let's say a person gave away $65,000 within the past 5 years and then needed to apply for Medicaid now. What would happen?
Okay, well, hopefully the person they gifted to could and would return the gift, and then we're fine, no penalty period.
I bet that rarely happens, though.
You're correct. In the past 10 years, I can probably count how many people could and would return the money on one hand. So what happens is that the $65,000 gift would be divided by the average amount Medicaid pays the nursing home per month, which is approximately $6,500.
But wait, I thought that West Virginia nursing homes cost about $10,000 per month.
Yes, they do. But Medicaid doesn't pay the same amount that an individual pays. Medicaid pays about $6,500 per month. So we divide that into the amount of the gift, which was $65,000, and that creates a 10-month penalty period.
Once that person is broke and in the nursing home, he or she is on penalty for 10 months and has to pay about $10,000 per month. But if they're broke, how can they do that?
Good question. That is a big problem, isn't it?
Well, it certainly is. Now I have a question about irrevocable trusts. Are they all basically the same?
No, I get that question a lot. There are different types of irrevocable trusts for different purposes. For example, just a few decades ago, irrevocable trusts were frequently used to avoid estate taxes, which people often refer to as the death tax. Irrevocable trusts can still be used to avoid the death tax, but due to changes in the laws, that tax is only for the wealthiest Americans, which currently is projected to be less than 1% of us.
Less than 1% of Americans are projected to pay the death tax? Then why would we want an irrevocable trust?
Because of the high cost of long-term care. Currently, most of my clients who create an irrevocable trust are creating it to protect certain assets in the event they need expensive care.
I understand the cost of care is scary, but what advantage does gifting to an irrevocable trust have over gifting to people like our family members?
Because bad things happen to good people every day. So gifting to a person is inherently risky, but trusts have less risk associated to them.
That makes sense, but what about taxes?
Well, the tax impact usually works out well. Generally, we draft the irrevocable trust that we call our box so that our grantors still pay the taxes on the income from those assets, just like they did before they created the trust. They can also reserve the right to live in their home and get all of the tax benefits of being a senior citizen who owns the home.
What if they want to sell the home and move to somewhere nice and warm?
Well, that's fine. The trustee of the trust can sell the home, and the proceeds from the sale would remain in the trust. Any of the trust assets may be used to purchase a new home.
But who owns those assets, the trust or the trustee?
The trust assets are owned by the trust, not by the trustee.
And that's good because bad things happen to good people, right?
Yes, if the trustee owned the assets, you'd have all the risk of all the bad things that happen to good people. For example, if the trustee became ill or had an accident, or even divorced or was sued, any assets being held by the trustee personally would be exposed. But irrevocable trusts do not get sick or injured. They don't have car accidents, divorces, or develop addictions. They just hold your assets.
That sounds perfect. The trustee doesn't own the trust assets, but the trustee controls the trust, similar to a manager of a store who works there but doesn't own the store.
Yes, the trustee controls the irrevocable trust, but the trustee doesn't expose the trust assets to any of the bad things that could happen to the trustee.
Do your clients ever struggle with giving control of the trust to their trustee?
Most don't, because they have a loved one that they trust.
Who is the trustee? Does it have to be a family member?
No, the person creating the trust chooses the trustee, and it can be whoever they want. Most of my clients choose a trusted family member, such as a child or children, but it could be anybody they trust, including a professional, such as a CPA or bank.
Let's discuss what is probably a common scenario. Mom gives her house to her irrevocable trust and makes her son the trustee. Then she wants to move to a smaller home, so her son, the trustee, signs the deed, and the proceeds from the sale remain trust assets. Then the son can use the trust assets to purchase a new home in the name of the mom's irrevocable trust?
Yes. So the plan can essentially change as mom's needs change without affecting mom's 5-year look back.
That all sounds perfect, but are there any disadvantages?
Well, yes, if mom isn't comfortable with her son holding that key, the mom shouldn't create an irrevocable trust because we don't want her to be worried or upset. She needs to have a trustworthy person to serve as trustee, and that person must follow the trust rules.
But if she doesn't create the irrevocable trust, her home or whatever assets she would have funded into the trust are exposed if she goes into the nursing home and needs to apply for Medicaid?
Yes, that's the trade-off. Retaining control of the assets and exposing them to the high cost of nursing home care versus retaining less control in order to gain asset protection. Most of my clients who have a trusted family member are pretty comfortable with the irrevocable trust.
So it sounds like if a viewer considering gifting or is concerned about protecting assets from a potential long-term care crisis, they should schedule a consultation to see exactly how the irrevocable trust would work for them. So now we understand how an irrevocable trust or safe box works. But how does a person who has disabilities protect their assets in an estate plan? Doreen will answer that question and more when Elder Care Answers continues. Welcome back to Elder Care Answers. We've been talking about how irrevocable trusts can protect your assets in an estate plan. But what about trusts for people with disabilities? Doreen, I understand there is a special trust for a person who has disabilities to help protect their money. Can you tell us more about that?
Absolutely. If you think about it, a person who is born with or develops disabilities during their lifetime is more likely to have a higher medical cost than somebody who doesn't. There are governmental benefits that serve as safety nets to those persons to make sure they always have some level of income and medical care. But these programs look at the person with disabilities, assets, and income to determine if they qualify, and if they do qualify, to what level.
If a person with a disability, say autism or Down syndrome, has limited income and assets due to their disability, they may qualify for SSI and maybe even Medicaid, right?
Exactly. But let's say grandma left her grandson some money when she died. That inheritance could cause him to lose his asset-tested benefits.
But he might not need them anymore if he inherited that money.
Maybe, but if he doesn't have that other income or Medicaid, he is probably going to spend through that inheritance pretty quickly and then have to reapply for those benefits. So the inheritance may not have helped as much as grandma had hoped.
Could she just disinherit him and maybe give his inheritance to a family member to use for his benefit?
Yes, but that puts quite a burden on that family member to do that. And remember, bad things can happen to good people.
Right, and that family member may not use it properly or pass away. After talking to you each week, I understand that a myriad of things could happen to disturb that plan. So I imagine you have another solution?
Yes, a special needs trust can hold the inheritance so that it doesn't disqualify him for benefits, and that a trusted family member or a professional trustee could manage the trust.
If the person with a disability had any type of windfall that could disqualify him from these benefits, whether it's an inheritance or a settlement from an accident or any other source, we could set up a special needs trust to protect the benefits?
Yes, and there are some limitations as to how the trust assets can be used, but it can be used for things that his benefits don't cover without disqualifying him for his benefits.
That sounds great. I mean, could other people put money into it too?
Well, yes, if a trust is created by a third party for a person with a disability, anybody can contribute assets to the trust. But if the person with a disability sets it up himself, others may not contribute assets to the trust.
Are there any other differences?
Yes, if a third party, such as a loved one, sets it up for the benefit of the person with disabilities, then anybody can add to it, and the person who created it can direct who gets it when the person with a disability passes away. But if the person with a disability creates the trust, nobody else can add money to it, and if there is any money left in it when he passes away, the state can recoup what it spent on him during his life before it would be paid out to the other beneficiaries.
Thank you, Doreen. Great information. So there you have it. Start preparing for your future by contacting Doreen at 304-554-2900. You can also visit Doreen's website, SeamonLawOffices.com, and follow Seamon Law Offices on Facebook, YouTube, and Twitter. You can request an appointment, read the blog, and find other resources to help with your estate plan, and there's always new information being posted. Thank you for joining us today, and we'll see you next time on Elder Care Answers.